The alternative would be to start the mediation process at the same time you start litigation. In other words, you make it clear to a client, there's a number of different ways that we can achieve what you want. And what we need to do is look at litigation, prepare for litigation, because that may end up being the best route, okay? But at the same time, we'd better look at mediation from day one and what's involved. And we need to prepare for that as well. Attorneys will find starting a dual process, in other words, preparing for litigation and preparing for mediation at the same time. I think they're going to find benefit because the client, when he first shows up, he or she first shows up in the attorney's office, tries to please the attorney. So they're going to frame their dispute as much as they can in legal terms. And they're going to, just as a matter of wanting to move forward in litigation, they're going to leave out a lot of information that the attorney really does need. It's the kind of information that comes out later in mediation. Many, many times we've gone forward, I've been co-mediating a settlement conference, and you'll see that the attorneys have missed something very important about the case. And there'll be that embarrassing moment when they thought they were arguing the law in one aspect, and it turns out the dispute is about something entirely different. And this often happens late in the process. If an attorney takes the approach that they're going to prepare for litigation, but also at the same time prepare for mediation, what's going to happen is they're going to discover in the preparation for mediation, they're going to discover the personal, the relationship issues that are working. And the client often won't bring those up when he's talking in terms of litigation. He maybe won't see that they're applicable. He maybe doesn't want to disclose them. But as he's preparing for mediation, in which he's going to have to take a bigger role, in which he's going to have to deal with relationship issues or other issues that might not come out in litigation, there's going to be, in a sense, the heart of the case is going to be revealed. Now, does that mean that it ends up in mediation? Not necessarily. It may be the type of case that has to go forward in litigation, but at least the attorney really has a depth of knowledge about this case. And so that's an advantage in starting out this way. An attorney might have a conversation with their own client about, does it make sense to enter into a settlement process? And they can have that discussion, but a more important discussion will be between all of the parties and their counsel. And a mediator could set up a very short 1 or 2 hour mediation that discusses why might we want to mediate this. In other words, so it just addresses those factors of convening. With the change in the court now, I don't know from the bench how strong the recommendation will be to go to mediation. In other words, that might not be as strong as it was when there was a panel with the court. So the whole question of convening takes on a new light. And it may mean that an attorney or attorney and opposing counsel together may want to set up a very short mediation session in which the whole issue is, do we convene a mediation? And the mediator is then able to work with the clients and pull out those personal aspects that are preventing them from settling this case. And that could be a huge plus for an attorney in terms of reputation, in terms of being able to service his clients in the best way possible.